As Brooks said, I'm Will Allen. For those of you who have just joined us, I've got a law firm in South Mississippi, a six-man firm, Allen, Breland, and Allen. We have been in the business of working with political subdivisions for 75 years or so. My grandfather started our firm in 1938, and he did work for political subdivisions. My father has been a board attorney for 39 years. I've been back in Mississippi for quite some time now, 16 years or more. And what we do, Danny's firm is very similar, family firm, that he does the same thing I do, and what we do every day is represent law enforcement officers. We do represent counties in general, so that if a bridge falls in and somebody has the intelligence to drive off of it, we take care of those kind of cases too, but probably 90% of what Danny and I do on a day-to-day basis involves law enforcement officers. We're going to talk about we're going to give you a brief overview today of some things that we see. There are ways that you can limit the liability of the county, ways that you can limit liability for yourself. What we try and do in these seminars really is give you some insider advice about the things that we're seeing, the things that folks are doing wrong, some things that you can do right, and that will help you when you get sued. Because honestly, if you're doing your job, it's not a matter of if you will be sued, it is a matter of when you will be sued. We're going to start off, and I'm just going to kind of tell you give you a basic overview. We're going to talk about two areas of law when it comes to law enforcement, and one is state and one is federal. The state law we're going to talk about is claims under the Mississippi Tort Claims Act. And under federal law, we'll talk about Section 1983. These are the two areas of law that you will most often deal with as a law enforcement officer. Let's start here, though. For many, many, many years, you could not sue the man, the government, political subdivisions. Sovereign immunity meant that the sovereign, the government, was immune from suit. The king can do no wrong was the phrase. And basically what this meant is that the king could take your woman, take your car, and there wasn't anything you could do about it. This, of course, is inherently unfair. So people started to make that known, and over the years, states, governments began to slowly erode that immunity and to waive it to a certain extent. I'm not aware of any state that has completely waived sovereign immunity. Certainly the federal government has not. The state of Mississippi has not. And likewise, political subdivisions within the state of Mississippi have not given an overall waiver. What they have done is pass the Mississippi Tort Claims Act in 1992, which is a, quote, general waiver of sovereign immunity, but they retained a number of restrictions, limitations, and immunities. So they sort of gave it away and said, okay, we're going to do away with sovereign immunity. And they reached out there with a bear hug and brought a bunch of it back and said, but we're going to put limits on when you can sue us and how. That's good for us. The Mississippi Tort Claims Act applies to all political subdivisions within the state. That means it applies to the Sheriff's Department, it applies to schools, it applies to cities. It is also the exclusive state law remedy. That means that if you are sued under state law as a law enforcement officer, it's going to be under the Mississippi Tort Claims Act. Now, if you're outside the course and scope of your employment, it's not going to be under the Tort Claims Act. So if you walk out here today and you see somebody out on the front steps that you don't like, say, for example, some Ole Miss fan, and you knock him in the head, that's assault, and that is not within the Tort Claims Act. However, if you walked out here and some Ole Miss fan was smoking marijuana on the front steps of this fine university, and you wanted to make an arrest and they fought you back, that's just, you had to subdue them and you might have had to knock them in the head. That would be within the course and scope, and it would be covered by the Tort Claims Act. Two distinct things. If you're doing your job, it's going to fall under the Tort Claims Act. This is the only remedy people have under state law. Why is all this important? It's important because it provides a lot of protection to you as a law enforcement officer. When you sue under the Mississippi Tort Claims Act, there are a lot of hoops to jump through. A plaintiff has to send us a notice of claim. If I drove out here today and as I drove off, I rear-ended Mr. Griffith, he could go right 10 minutes from now to the courthouse and file a lawsuit against me. But if one of you did it, and you were on duty in your car, he could not do that. He would have to file a notice of claim and send it to the Chancery Clerk or the President of the Board of Supervisors, and he would have to have 7 pieces of information that are set out in the statute explaining why he proposed to sue the county. All right? That notice of claim is a hoop they have to jump through. You'd be surprised, even though it's right there in the statute, how often that gets fumbled. They also put in the Tort Claims Act a 1-year statute of limitations. Same example. I go out here and I run into the back of Mr. Griffith. He has 3 years to sue me. You run into the back of him in your car, in your sheriff's car, he's got 1 year. That's a big, big difference. Not only does he have to submit a notice of claim, but he has to file suit within 1 year. So there's some technicalities that actually extend that time period past 1 year. He's got 365 days to file the notice of claim. Then he's got to wait 90 days, and he's got another 95 days to file the suit, but it's much shorter than 3 years. There are caps on damages. Y'all will remember Mississippi, all the doctors got up in arms. They wanted caps on lawsuits. Y'all didn't have to do anything. You already had it. It's $500,000 limit or the limits of your insurance. So if your county carries a $1 million policy, that's the cap. If it doesn't, it's $500,000. No punitive damages are available. You can't sue an officer in his individual capacity as long as he's within the course and scope of his employment. And we're entitled to a bench trial. A bench trial simply means that the judge is the fact finder as opposed to a jury. The reason this is important is because judges are not as subject to, let's say, emotions. I'm not saying they're not emotional, but they're used to seeing this kind of stuff. It's not like getting somebody on the jury who's going to get really emotional and invested in the case. A judge looks at the law, he or she's much more able just to apply it. So that's a big difference there, that we get a judge, not a jury. It's important for you to know that every time you walk outside in that uniform, that you put the county's assets on the line. You also put your own self on the line. So you've got your reputation, the sheriff's reputation, the county's money, and there are certain instances where you put your money on the line, but it's very, very limited. Under the Tort Claims Act, personal liability is extremely limited. If you're in the course and scope of your employment, then you can't be held personally liable. They cannot come after your money. They can only go after the county's. Well, that means it's super important for you to understand what's in the course and scope and what's not in the course and scope. Because if you're acting outside the course and scope, your bass boat, your four-wheeler, your fun toys are on the line. As you can see here, the statute specifies certain things that are absolutely outside the course and scope of your employment. If you act in a way that's fraudulent, or you act with malice, you act maliciously, you commit slander, defamation, those things don't have anything to do with your employment. You're outside the course and scope. Tort Claims Act will not apply to protect you. Same thing for a criminal offense. As I gave you my example earlier, you walk out here and see an Ole Miss Rebel fan and hit him in the back of the head for no good reason, and being an Ole Miss Rebel fan is not a good reason. That's assault. And you're outside the course and scope. Doesn't matter that you wear a badge. You don't get the protections of the Tort Claims Act. On the other hand, if you're making an arrest and somebody fights you and you have to subdue them, that will be in the course and scope, and you will be entitled to protection. You want to stay within the course and scope. That makes sense? The primary thing that you're going to see or hear talked about when you get sued as a law enforcement officer under state law is going to be the police function exemption. The Mississippi Tort Claims Act contains something like 25, 30, 36? 26. I was close. 26 exemptions. These exemptions mean you're completely immune from liability. The county is immune from liability. They can sue you and cannot recover. The most important for you is this one. It's 11-46-91C, the police function exemption. This is a definition from the statute itself. It's nearly incomprehensible, but it essentially says that there's immunity so long as you don't act with reckless disregard for the safety and well-being of someone not engaged in criminal activity. Now that's a lot. So it breaks down to really two avenues of immunity. If you fall within either one of these avenues, there's no liability for you or the county. One, if the person making the claim is complaining about conduct that occurred while they were committing a crime, they're out of luck. That's why in pursuit cases, the driver never gets to make a claim. The driver is fleeing the police, which is a felony, and he wrecks and hurts himself. He can't sue us because he's committing a crime. It's always the granny that gets run over, or the passenger, someone who isn't committing a crime in those pursuit cases, that makes the claim. And the reason behind this is pretty obvious, right? I mean, if you're having to chase somebody down and you tackle them and they knock their front teeth out, they ought not be able to sue you for that because they were engaged in criminal activity at the time and you had to detain them. Make sense? Unfortunately, we don't get the opportunity to use that exemption very often. Primarily, we're looking at this, the second prong, which is we have no liability as long as you didn't act with reckless disregard for the safety and well-being of another. I'm going to talk in depth about that, but let me tick off a little bit of a precursor. For this exemption to apply, you have to have been engaged in police-related activity. All these things are pretty obvious that they're police-related, right? You draw a gun on a suspect, you detain someone, you end up shooting someone who's resisting. These things are obviously police-related, okay? Plaintiffs would like for this to be the only list. They want it to be only if you're drawing a gun on a suspect, all right? But it's not. The Tort Claims Act is very much favorable to you. There are a lot of things that may not seem like they're police-related that actually are. Driving your vehicle to have the brake service, well, that's police-related. Driving to lunch, that too is police-related. This last example here is a case that I had in Wilkinson County. A guy went to the hardware store to get copies of keys made, the keys to the county gas pump. He got the copies made, he was leaving, he came up to a T intersection, ended up having an automobile accident. We went, I argued the motion to dismiss, the plaintiff's lawyer was livid. You know, he said, Judge, police-related activity is drawing your gun, it's making an arrest, it's chasing a suspect. It isn't making keys for the county gas pump and driving your dadgum cruiser. The judge said, I disagree, it's police-related. Took it all the way to the Supreme Court, the Mississippi Supreme Court said, that's right. He was on duty, he was doing something that the sheriff asked him to do, that's police-related, even though he's not drawing a gun. So it's much more wide open. I was telling some folks yesterday, I had a case, give me a sec, I'll come to you. I had a case where an officer was at a drive-through car wash before work. His shift started in about 30 minutes, but the sheriff had a rule. You got to have your car clean. You can't do it on shift. It's a bad rule, but he had that rule. Guy pulled out of the car wash and wrecked. Plaintiff's lawyer said that is not police-related activity. He's having his dadgum car wash. And I said he's having his dadgum car wash because the sheriff told him to, and he had to do it on the job. Judge said, that's right. That's police-related activity. Mr. Griff.
Case about 2 years ago, law enforcement officer is working part-time on an ambulance detail because he is an EMT. Even though he was a law enforcement officer, he was not entitled to claim the law enforcement immunity provision because he was working as an EMT on the ambulance.
Not a law officer.
Not as a law officer. There are some concerns along those lines that we need to discuss when we have our discussion period dealing with independent contractors.
Right. Yeah,
we can kick that to the end, but we already have a couple questions.
We have. Okay. So again, if you'll remember, the first prong of immunity is if they were engaged in criminal activity. I just wanted to let you know, there doesn't have to be a conviction for us to use that prong, okay? You don't have to go get a conviction, prove beyond a reasonable doubt that they were involved. You just got to show they were involved, and that can be, I saw it, and that's that. That's enough. You don't have to have that conviction. In most instances, a traffic offense is not going to be sufficient. There's a case where a guy was going let me say that. There also has to be a connection between the criminal activity and your conduct. The court says it can't be merely fortuitous. What that means is it can't be luck of the draw. Guy's going to lunch in his cruiser, really rolling fast, not an emergency situation. 14-year-old without a license pulls out in front of him, they wreck. Officer says, hey, criminal activity, unlicensed driver. The court said, you got lucky and hit a driver who didn't have his license. It had nothing to do with why you were speeding. You know, your conduct was your haul and tail going to lunch. That has nothing to do with this kid being an unlicensed driver. On the other hand, if he was in a hot pursuit and he had a wreck of some sort because somebody was drunk driving, well, there's a connection between the conduct. It's hard for me to come up with an example because honestly there are very few examples in the case law. The only one I can think of is the Richardson case where there was a firefighter in a fire engine, drunk. He pulled through an intersection and our officer hit him, and they said the fact is he was drunk and that conduct was related to why the accident happened, so it wasn't merely fortuitous. Good enough example. There really aren't any good examples of that, but you can understand it's got to be tied. We don't get to use that. This is primarily where you're going to land. Something's going to happen, you're going to get sued, and we're going to say, no, there's no liability because our officer didn't act with reckless disregard.
Clearest example you could have, bigamy is still against the law in Mississippi. If a man and his 2 wives are in an accident with law enforcement.
That's not going to be sufficient. No. Yeah, back here. That's not going to be sufficient, right? That doesn't have anything to do with what was going on. You just happen to run into a man that likes 2 women, to be married to 2 women. Now, that why anybody would want that? One's enough. I just said that on video. Reckless disregard. Let me pull this out for you and show you what this means. If I go outside and Danny and I are leaving today and I run into him, he wants to sue me. He just has an ordinary care standard. It means he's just got to show that I acted in a way that a reasonable person would not have acted.
That's not a problem.
Thank you. Thank you very much. He's got to show that a reasonably prudent person under the same or similar circumstances would not have acted the way I acted. If you go out here and run into Danny Griffith, he's got to show you acted with reckless disregard for his health and safety, more than negligence, more than gross negligence, a step below intentional conduct. It's essentially conscious, deliberate action that harm should follow. The best way to explain this, and I know Danny's heard me do this 5,000 times, but the way I explain this to a judge when I'm arguing my officer's entitled to immunity under the police function is I say, Judge, there's 3 cases that exactly explain what we're going to look at. 2 of them set the pole stars and one's in the middle. On the one side, you've got Turner versus City of Louisville. Now, Turner is a case where a guy was driving drunk. Officer pulled him over. He was visibly intoxicated. The officer knew it, could tell it. Old boy that was driving gave the famous plea, look, I'm 2 blocks from the house. Just let me get to the house. And this poor officer agreed. He gets in the car, drives off, and a catastrophic wreck occurs. Court said at that point, when they denied a motion to dismiss and said, you know what, we're not going to give you immunity. When you let a drunk back behind the wheel, that's more than negligence. That's reckless disregard. Knowingly allowing a drunk behind the wheel, now that's reckless disregard. Joseph versus City of Moss Point was a case where a guy had given a ticket and had actually pulled back out on the roadway. There were 3 lanes. 2 lanes were north and south and had dedicated traffic signals. There was also a 3rd lane on the inside that allowed you to turn to the west It had a dedicated green signal, the turn signal. This officer was finishing something up in his ticket book when out of his peripheral vision he saw some cars start. He assumed that his lane was green. You know what assume means? His lane was not. The left turn signal was still red. He let off the brake without looking up. 5-mile-an-hour rear ender. They argued that's reckless disregard. He didn't look up. The court said, no, that's simply a mistake. That's just negligence. That's not reckless disregard. It's not like letting a drunk back behind the wheel, okay? The other case, Reynolds, is my case, and that's the one I told you about, the car keys being made. In that case, my officer went down and made the keys. He came up to a T intersection, and at that T intersection, he's driving north, comes to the west to east street, and on the west to east street, there were cars parked at an angle. He could not see around the end of the cars. So he pulls up and looks, and he can't see. He pulls up a second time. He can't see. When he pulls up the third time, bam. He hits a lady who was traveling from the west. Not only did the plaintiff's lawyer argue like crazy that that wasn't police-related activity and lose, he argued that that was reckless disregard. He thinks that the guy should have gotten out of his car and gone and looked. Now, I pointed out to the judge in oral argument that by the time the officer got back in his car from looking, he probably had to get out again and go look again because too much time had lapsed. I said, that's silly. The judge agreed and said, this is just a little auto accident. It's not reckless disregard. You see how this fits together? So we get calls all the time where an officer has had a little fender bender in a parking lot. We're never concerned about that. Your sheriff may want us to pay that claim because it's a voter and it's your fault. But the fact of the matter is we have no liability. You can't be held liable because it's not reckless disregard. Does that make sense? The most common theme we see when they're able to pierce that standard of reckless disregard is speed. Speed. You know, they always say speed kills. That's what kills the reckless disregard standard as well. If you're speeding in a non-emergency situation, you're almost certainly going to be held liable. That's the long and the short of it. I told those guys yesterday, nothing drives me crazier than when I'm riding up I-55 and I see a county or a city officer fly by me doing 90 miles an hour with no blue lights and siren on. Clearly speeding for the sake of getting somewhere fast that's not an emergency. Speeding because you can speed. That's reckless disregard. If you have a wreck, you're going to be held liable for that. The county is. Perry versus City of Jackson was that case I mentioned a minute ago. He's speeding going to lunch. He's not running code, and he hits a 14-year-old, and the Hinds County was found liable. Running code, does that mean just putting your lights on? No. What else needs to be on? Siren. If you do not have your lights and your siren on, then you are not allowed to exceed the speed limit or break any traffic laws in the state of Mississippi. As we said yesterday, a yelp does not count. I do not know what it is that makes people think they need to hit that intersection and go, yip, 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 yip. That's not sufficient. It's got to be on all the way. It's got to be on continuously. If you turn it off, you better slow down to the speed limit and not break any traffic laws. You cannot do it. I have a municipality near me where the chief of police has told his folks, that you are not to turn your siren on in the city limits, only your police lights. And he says it bothers the citizens of this particular city. And I've explained to him that he's going to be held liable, and he doesn't care. The fact of the matter is, running blue lights alone, no matter how careful you are, is insufficient. I love this part about, I always point out this part right here about the statute. It says siren, exhaust whistle, or bell. So just in case you wanted to ring a bell for your siren, that's still acceptable apparently in the great state of Mississippi.
Let me give you a point or two under the Tort Claims Act before we move. A case came down on the hand-down list yesterday, and it reflected something that was already in the law a bit. There are multiple provisions of that immunity statute. One of those is discretionary immunity, and it's something heavily argued about, but it still works for us on law enforcement cases. It goes basically like this. There are cases that hold now that supervision, discipline, training, making policy under law enforcement is discretionary. Now, those are all topics under 1983 I'm fixing to cover in a second that are keys that lead to liability potentially against the county. But there is an immunity under state law that will work that way. Picture the scenario of a suspect already in handcuffs. He spits on the officer. The officer, as experienced as he is, has a moment of poor judgment and pops him a few times. He's outside the course and scope. He's not protected by the Tort Claims Act. We don't assault people in handcuffs. I've got a problem on the federal end as well, but on the state end, he's not protected under state law. Chances are, if somebody goes and reports it, which his fellow officers have a duty first to intervene and to report it, unfortunately, but that's the way it is, he's going to at least pull a misdemeanor, and if he pulls a federal misdemeanor, he's not going to have coverage anywhere. So he's going to be all alone, which is really sad. But under that same circumstance, if they cannot sue under the Tort Claims Act, yet they want to stay in state court, then you end up sometimes with a charge where they're saying, oh, but it is the city's fault or it is the county's fault because he was under their supervision and he didn't meet this training requirement or he didn't meet that training requirement or the department should have a different policy. Those type of policy arguments to try to get to the entity, whether that be a city or a county, run into another one of the immunities. Just keep that in mind because that is out there. But that discretionary immunity can also help us. There's a case out of one of my regular clients, the city of Rouville, where they were attempting to make service on an arrest warrant, and the person was dodging them. Well, the same person that was dodging them killed someone in a domestic violence homicide. When the city was sued, it made it to our appellate courts, and they held that because decision making was involved, it qualified for discretionary immunity. So they were not able to make a claim against the city by and through the police department for failing to get the warrant served on a person who was hiding, which makes sense. It didn't necessarily make sense to me as being discretionary immunity. I would have considered it a reckless disregard issue and would have probably found it immune for the same reason. But realize we use other immunities too. But our go-to, if it's a law enforcement case, is going to be law enforcement immunity. And if we're dealing with police pursuits, the person that we are chasing is, in most instances, committing a felony by fleeing from us. He can't sue. But the problem is his innocent passenger sitting in the seat or the person that he hits while he's running from law enforcement. That's how we pull the lawsuit. And what happens with that kind of suit is in state court, again, we look to provisions of the Tort Claims Act. You just have to be very careful with police pursuits. They're one of the biggest areas of liability we have. And not so much on the federal side, because you probably are aware of this. There's federal authority, especially in the context of the Fourth Amendment, if it's the person you're chasing, that if they're driving in a manner that is a severe risk to others, you can use deadly force to stop them. But back under state law, a third party injured is not going to be able to sue under federal law because that third party injury under federal law has to go under the 14th Amendment, and they almost have to meet an intent to injure standard. So, in other words, to boil all of that lawyer talk down, if they're going to sue you for a police pursuit, it's just about going to be a third party victim, and they're just about going to have to walk that line through the Tort Claims Act. And like we say on the slide, be careful. It's not worth hurting anybody, but if you make a negligent mistake, it's not liability. Let me give you an example. There was a case in the city of Jackson. Lady goes through, these are the basic facts. She goes through a bank, she's trying to pass a hot check. They had her identified. She runs from the scene. She's not a bank robber. She goes running down a very, very busy street, County Line Road, I believe. Multiple officers chase in violation of the law enforcement policy that they have down there. There's an accident where a third party's injured. Typical, the third party where there's serious injuries goes and hires a doctor expert to come in and pick apart the municipality's policy, the conduct of the officers. They take a reconstruction of the accident scene. They criticize speed, tactics, you name it. But the name of the game is to show that the officer acted in reckless disregard. So in that case, they said yes. Multiple factors that they talk about, in this case and others. And when I do one of these and I'm in front of a judge, because we do them in front of a judge, not a jury, typically we will either propose a finding of fact or the judge will make one on every one of these factors. What was the length of the chase? What type of neighborhood? There's a big difference between 4-lane County Line Road, packed full of traffic in Jackson, and a rural gravel road. You know, there's a big difference on a straight road that you can see and something going over hills with no passing lines. They look at weather. They look at multiple other factors. Speed and blue lights, they're either going to help you or hurt you. If you're chasing somebody, surely you're going to have your lights and siren on. I've got a problem if you don't. I'm going to have a hard time defending it. Look, nothing is a dead bang loser. Sometimes a little bit of gamesmanship works, but it's sure easier if you fall within what the courts have recognized to be protected conduct. Suggestion. One of the things that I run into when looking at this list, and one of the things that I've had in cases that really posed issues, is where the other side will try to pick apart what your departmental policy is. And there are basically 3 kinds of pursuit policies. There are 3 kinds that are in the DPS book. There is a policy that says don't do it. Now, if you've got a policy that says don't do it and you pursue anyway, in other words, don't pursue a misdemeanor and you do it anyway and nothing happens, well, that's fine. Nobody can sue you. Nothing happens. It wasn't an injury. But if you pursue and you're in violation of policy, it's not going to make you automatically liable, but it gets started and looking that way real quick.
Pretty close, though.
Yeah, really looking that way pretty quick. The other 2 kinds of policy, one is a kind of a restrictive discretionary policy, and that's one, and I tend to favor a more restrictive policy that basically has somebody else in supervisory control that can pull the plug on a pursuit. That works for a lot of reasons we'll discuss a little bit further. The third kind of policy is pure discretionary. We leave it. We send him to the academy. He's got good judgment. Turn him loose. There's a sheriff out of Texas. I believe he was the one that spoke at one of the conventions the other night. His policy is call me at the Panama Canal. But we're better, and we pose a high liability risk if you do not have supervisory control. I can work with that. The cases that I've got a restrictive policy and I've got supervisory control over it. Now, there may be something else that happens, like a use of force incident when they catch him. But seldom do we have problems with when we've got that supervisory policy in there. The other thing, and we'll probably have some comments on this, alternatives. What do you see, Will, in terms of concerns about there being lesser alternatives? Let's assume we can identify the person, we know who they are, and it's a minor crime. Should you chase them?
Yeah, here's what we're seeing, and I'm seeing in both the case law and in oral argument. The thing the court is honing in on is, was there an alternative to this chase? They want to dissuade us from making these pursuits because there's just so many things that can go wrong. And if you have a good ID on this person, the court's going to lean really, really hard towards the idea that you should not have pursued them unless they're an immediate threat. If they've kidnapped somebody, if they're carrying a pipe bomb or 12-gauge shotgun that they have told you they're going to go use on somebody, those people are obvious dangers. We got to get off the street. If they're high or drunk, you know, somebody leaves a DUI stop hammered, runs away and jumps in the car and takes off, you know, you got to make a decision right then. I probably need to get this person off the road before they kill somebody. On the other hand, if there are valid ways to get this person, you know the ID, they're in their regular car, you know where they live, the court is going to want you not to pursue that person. The reason for that is this. Let me give you an example. I had a case in South Mississippi where our officers had set up a roadblock between two counties. They knew that this was a very well-traveled road by users and sellers of drugs. They stop a car. It's got a 19-year-old in it who got popped for marijuana several days, 5 to 7 days beforehand. They knew him. They knew his grandmother. They knew where he lived. He was in his car with his with his license plate. He did not have his driver's license, but he had his work ID. They knew this kid. He takes off. They jump in behind him and chase him down some very curvy, small roads, run him under an 18-wheeler on Highway 84. Doesn't kill him, kills his 14-year-old cousin. Okay? I couldn't tell the court why we needed to pursue the boy. Only thing he had done wrong was he did not have a driver's license. And he ran because he was scared about the marijuana charge. But I got no good reason to tell the court why we decided to pursue this guy and run him out into a major highway when we knew exactly where he lived. We passed his dadgum house on the chase and knew it. That's not defensible. I got to pay for that case. The guy that rides with me all the time was my investigator, was the sheriff of Copiah County for 3 terms, and when we passed this particular intersection, he always laughs and calls it Will's intersection. Because they've fixed it since then and made it where it's more difficult for that to happen, but we paid a lot of money for that dead 14-year-old, and there was no reason to pursue him. The courts, whether you want it to be this way or not, the courts don't want you chasing folks. I'm not telling you don't. There are times we have to, but they don't want it. And it's going to be very closely scrutinized. Agree?
Yes. There are other circumstances beyond a pursuit that I'll use almost this same analysis. Emergency response driving, we pretty much use almost this same analysis, but you don't look at what the offender's doing in the threat there. For example, I have a situation where I had a young child having seizures. It was a severe medical emergency. A helicopter had been ordered, and the particular department needed to get an officer to the scene to accommodate landing the helicopter to get this child help. Does anybody, under anybody's policy, have a problem with running code to get there, to get to the helicopter for a medical evacuation? No, not anybody in law enforcement in Mississippi I've met. Now, there may be circumstances in downtown Jackson where they wouldn't want you doing that, but if you're on a nice, straight, dry, sunlit county road, running code, traffic's yielding to you, go do your job. And those circumstances, though, that thought process, we have to think about and go through that, and we have those kind of cases. What you can expect me to do in a case like that, I'm gonna, probably by the time I get involved, the highway patrol, if it has done some type of reconstruction. If not, I'm gonna do one. If it's a serious injury case, we're gonna get the personnel files on everybody involved. We're gonna get all of the photographs. We're gonna interview the people that we need to interview. And then before we go very far in the litigation, I'm gonna file something with the judge, because it's just about always gonna be in state court. And either we have a hearing on it and the judge grants what I ask for, or the other side caves and grants what I ask for. But the things I'm gonna try to do are, number one, I'm going to get that individual officer out of that case. He's on the job, he's 10-8, he's responding to something legitimate. He doesn't need to be named individually in that case. I'm going to get him out of that case when we start. The second thing I'm going to do is have the judge, or request that the judge, and he's got to do it, it's all statutory, have the judge limit discovery so that he can't make us run up a big bill doing things that we don't need to be doing. I'm going to have a judge, and I'm going to cite discretionary immunity and law enforcement immunity and anything else that I think we ought to apply, like damage caps. And the case, further development in the case will be limited to that. And you can just about say that you've started an hourglass. Once you get that order entered, they're either going to quit or we're going to do limited discovery and come back and go in front of the judge. Now, if it's a circumstance where we have a pursuit that's off policy, or we have a pursuit under conditions that it shouldn't have taken place, or we have a pursuit, frankly, that does not have a lot of value, that we didn't need to be doing that, those are cases sometimes we have to resolve. And I have lots and lots of law enforcement driving cases. We don't resolve many of them. Fender benders, car wrecks, those are unfortunate, and like Will said, there may be a political reason where somebody may want it paid, but my job, until somebody tells me different, is to defend it and win it. And so that's just kind of what to expect from us when we come. And when the accident happens, if it's in your own department, although it's not safe to assume, I would assume that y'all are starting to file. And everything is collected. Every document, every photograph, every potential witness. If somebody that's a witness and he leaves a department and you know there was a fatality in some accident and it's probably coming in litigation, make sure we can track them down. Now, finishing through police pursuits. If we're running into a narrow country road or a crowded, busy city street, if we're in a situation where you cannot see well or you cannot reasonably predict the threats. And by reasonably predicting the threats, to me, if I've got an officer and he's going down the road and he's running code and an 18-wheeler pulls over onto the shoulder and people are yielding to him, what message is that sending to you? Okay, everybody's doing what they're supposed to do, I'm doing what I'm supposed to do. Now, if we have a wreck because somebody who doesn't have any business driving out of the blue comes pulling out in the road and doesn't yield, that person isn't going to be able to sue us, or he isn't going to go anywhere. But just keep these in mind because they're a huge source of litigation. Now, we put some points in here that are good to know and good to think about, and I've really kind of already ahead of myself covering that, and that is preserve as much evidence for the civil part of the case as you can. When I walk in some departments and they hand me, I already got you a folder on this, and I got this, and I've got here's a copy of our pursuit policy, here's the certifications on the officer. Life is good. You know, we're not perfect, but the more information you give us, the better you arm us, the better you're prepared, the better job we can do to fight for you. And if it's a wreck and it's involving county personnel, it's really difficult to be objective. Whatever your circumstance is, now we have metropolitan departments and we have departments that are quite rural. Whatever the arrangement is, there are places that you get a city to work the accident. There are places that you get the highway to work the accident. It's hard to work your own accident unless you just don't have a choice. Now, a few points, because this isn't a liability issue, this is your life. Not enough police officers wear seatbelts. No way in the world that you ought to be texting going down the road. I observed somebody this morning who had to be texting or answering a cell phone as I was following them. And I know because I filmed it with my cell phone. But anyway, but
one of the things that we're seeing more and more is right out of the gate in these cases, plaintiffs' lawyers are subpoenaing cell phone records so that they can look and see, one, who you're talking to, because it's fun for them if they can catch you, you know, dialing 900 numbers. But the other is to see if you were on the phone at the moment that this incident happened. It's not good if you are.
And another thing, while we're going off topic, we're better off topic anyway,
Another thing to concern about is more and more, everybody's going to be mic'd up. Everybody is going to be taking pictures. If you have a live open mic, which is not my favorite thing in the world, but there are things I'm not going to say on a live open mic, and I would hope that I'm not the only one who's not going to say certain things over a live open mic. I'm going to watch my language. If I know I'm responding to a call, I'm not going to be talking to my girlfriend. I'm not going to be sitting there. I have 45 minutes of tape at an accident scene where the deputy got out of the car, open mic, walked up and talked to the sheriff at the accident scene, and they said some things that were inappropriate. Didn't cost us. I mean, I produced 6 hours of videotape. They didn't look. Thank God they didn't look. Because you've got, you know, shame on you. If you got a picture and you know you're on camera, if you got a mic and you know you're mic'd up, act accordingly. And that's probably why cameras are good.
Yeah. They're going to get the dash cam, body cam. They're going to get that.
If you get out of that car and that car is on a dash cam and you're mic'd up, you make sure everybody knows they're mic'd up. I mean, just people say things, odd conversations that have nothing to do with anything. But if I'm dealing with a death case, two officers who are talking about their mutual interest in some third-party young lady at an act, anyway, do I need to say anything else? No. All right, 1983. 42 U.S.C. section 1983 is just a code number. It just was the next one in line when they were numbering the statutes. But it's a set of civil rights statutes that were designed to provide a civil remedy, money, attorney's fees, recovery of damages for violation of somebody's constitutional rights. Now, the kicker first is under color of state law. And that can be just a pass-over issue, or it can be a real big issue. It becomes a very big issue under 1983 if you are performing off-duty work but you're in your uniform. I've had the case. Sometimes it's color of state law, sometimes it's not. Most departmental policies need to have restrictions on off-duty employment, because you need to know when you're on the hook and when you're not on the hook. Because color of state law doesn't mean you necessarily have that authority, but you're acting like you've got that authority. And that doesn't mean necessarily that your entity's going to be liable, but it will get you individually liable if you violate somebody's constitutional rights. Now, we don't have listed on here the First Amendment, but I am seeing more and more claims against law enforcement in the context of First Amendment. And you can expect it. People are taping and videoing things that we're doing. You get some of the most ridiculous things imaginable said to you. People just don't realize. It's just amazing. I don't have the temperament for it. You know, First Amendment liability in the context of a retaliatory arrest is real and out there. Now, very few cases are actually viable First Amendment cases. But if you have a qualified civil rights attorney who doesn't mind accusing you of whatever it takes to get to a certain stage in a case, then you're going to get accused of it. Now, my opinion of the ethics of doing that is probably self-evident from what I'm saying. But it's just like we have with warrants. When we have warrant exceptions on Fourth Amendment claims, I'm golden most of the time. My Fourth Amendment claim is based on what? Somebody having probable cause to effect an arrest. And I've got a warrant. A judge already decided probable cause. You have people who will, in their complaint, to survive a motion to dismiss, they're going to accuse you of lying to the judge to get the warrant. Anybody ever, there was a wonderful movie a couple years ago, had, Robert De Niro, and he's testifying, he's a priest on the stand. And of course, he's given an alibi for somebody in a trial. And he said, well, even a priest with ticket stubs wouldn't need to lie. So document what you have when you get your warrant. Make sure that you've communicated enough information to the judge. Never act on a warrant that you think somebody has just rubber stamped, because the strength of that warrant will cover you. And they will more and more accuse you of basically using a fake warrant. And I've got to go through the factual development to show that you legitimately obtain the warrant and the warrant is valid and that you're able to rely on it in good faith. Eighth Amendment claims. I know this is law enforcement and not corrections, and Eighth Amendment comes up most of the time in jails. I got a ruling yesterday, day before yesterday, 25 pages long on a jail suicide, and all of my officers were street officers. They were all city, municipal, full-time certified officers. They didn't have a jailer. So it wasn't a jail case, but it was an Eighth Amendment case. So having an understanding of your duty to communicate certain things is a really big deal. We're going to talk about it a little bit. This isn't a jail seminar, but it's worth knowing at every point that you've got the opportunity to pass on needed information to somebody else when somebody's in custody. You gotta do it. You gotta pass on the threat level. You gotta pass on the factual information necessary for them to do their job. That way nobody gets in the business of pointing fingers and saying, he didn't tell me, she didn't tell me, I didn't know. Because I didn't know, that's not my job, doesn't work for us. Never works for us. Now, that doesn't mean that I don't blame it on the state sometimes when I get half a chance. But it's not something that you guys get to say. 14th Amendment claims are typically some of your jail claims, and then there's some due process claims. And we mentioned in a pursuit that a third party individual gets hurt and they try to make it federal. That's a due process claim. That's depriving somebody of their liberty without due process. Now, the U.S. Supreme Court has said that it has to rise to the level of intent to injure. I have yet to see a viable 14th Amendment-based pursuit case. But I've defended a few of them, and I'll defend a few of them more. So you need to know what's out there. Now, differences with the Tort Claims Act, we kind of already talked about. You don't get a jury with the Tort Claims Act. You do get a jury with a federal claim. In a federal claim, you have qualified immunity as opposed to statutory immunity that's created by the legislature under the Tort Claims Act. Tort Claims Act, no punitive damages, no individual liability at all. And the federal claim, if you get individual liability, in many cases, if they determine the conduct to be basically malicious and intentional for all practical purposes, you tend to have exposure to punitive damages. And nobody really, and the way punitive damages come up in an individual federal trial, they've already tagged you at that point. And now you come back and you go in front of the same jury that just tagged you, and then they look at your assets and they look at what money number they're going to put on the case to punish you. And it's not a real good proceeding to sit the, it's discretionary with the judge in federal cases. They don't always, even in cases of liability, they don't, I have lost a federal case where the judge didn't award punitive damages, didn't allow the jury to consider it. Actually, I lost one that, and I lost a lot, but I lost one where the plaintiff's attorney, I believe that he was so surprised he won that he didn't ask for a punitive damage phase. So we got on the elevator and left. So the biggies with 1983 in terms of what to expect if you're the governmental entity. Well, in law enforcement in Mississippi, if you're dealing with a county and you're the governmental entity, the sheriff is considered the policymaker, unless the sheriff is personally involved. In other words, out there making the arrest, or out there making the commands, or out there participating in the pursuit. And I've got a sheriff who likes to ride around at night, and I've had more than one pursuit, and when I get the audio, I hear him on the radio. If it were a bad pursuit, we don't have to go through all this policy issue, whatever, because the sheriff's participating. it is better, and I have recommended it repeatedly. Let's say that there is an officer-involved shooting. Let's say that there is a situation beyond just like a traffic accident, but an officer-involved shooting. As much as you hate to do it, if you're the sheriff, chief deputy needs to go. That's just my best advice. Sometimes for public perception, you just have to go. If it's one of your officers and he's been hurt in an accident, I understand that. But our job here is telling you what we would like to see, not necessarily what's going to happen. Because if I'm a sheriff and if one of my deputies has been in a car accident, I'm going to go. But realize that the best legal advice is to have a designee, your chief deputy, be the one to do that, be the one to call an outside agency to investigate. Because if you're calling the shots, you're going to be put in the middle of it. Now, the other way to make the county liable is if there is a policy that the county has that's unconstitutional on its face. Never have ran into it but once, where the policy was actually clearly unconstitutional. You know, it's possible. So if the sheriff doesn't participate, and if you don't have an unconstitutional policy, how are you going to get to the county under 1983? Well, you're going to have to show a widespread practice that is so bad that everybody should know, that the sheriff should know. You probably need to try to show direct notice to the sheriff, and you should show that he or she did not do anything about it, and it rises to the level of these institutional bad habits actually being unwritten policy. That'll get you liable. Now, I have situations where there is no policy at all. Case I won 2 days ago, they didn't have a policy at all. They don't have a jail. They got a holding cell, so they didn't have a jail policy. Everything was verbal. Not a problem. It's a problem to defend, but those are winnable. Having a bad policy is a problem. Having repeated policy violations that you ignore is a big problem. Look, the biggest concern for individual liability under the federal claims is that they can go after your personal assets. There's the possibility of a punitive damage award. The biggest defense is qualified immunity. There's a bunch of tests for it, but the easiest way to express it is that if in a room full of officers, if you get really specific about the conduct, in other words, between me getting you down on the ground and actually having you in handcuffs, do I have to take the dog off of you? It's not using a dog, it's not whether I warn, it's very, very specific, a qualified immunity question. And if every reasonable officer would know that it would be unconstitutional, we say unlawful, but that's what we mean. If everybody knows it would be unreasonable force under the Fourth Amendment to do that, then you don't have qualified immunity. It's that strong. Most of the reversals on the federal cases when we're dealing with Fourth Amendment cases come back and forth on qualified immunity. It seems like I'm writing a brief on them quite often. Now the standard of care, we're talking about the Tort Claims Act, and we talk about law enforcement cases and them having to show reckless disregard. Well, negligence isn't enough for a 1983. And I have that sort of situation. I have a situation to where I've got a live feed camera from a jail cell to a dispatcher at the front, and the dispatcher's too busy to look at the camera and notice that the subject has taken his own life. Now, he wasn't acting in conscious disregard. He's trying to do a dozen things at once. We all are going to multitask ourselves to death. But now, if in the process of doing your job and multitasking, you miss a detail, that's not enough. They had a jail suicide case out in Texas, fancy jail. They had a jail psychiatrist The jail psychiatrist met with the guy. He is drooling and beating his head on the table saying, "I want to die." The doctor, in his wisdom, concluded that the guy was faking and sent him back in the cell. Well, now, it wouldn't be a lawsuit if the doctor wasn't wrong. So the guy goes back, takes a sheet, and hangs himself. You can kill yourself pretty quick. But the doctor made a judgment, a conscious judgment. He was just wrong. So there isn't any such thing as a medical malpractice case under 1983. There isn't any such thing as a negligence case under 1983. It's got to be reckless disregard. It's got to be deliberate indifference. It's got to be something way more than negligence. They play around with the language, but way more than negligence, almost intentional. There's no audio, but it kind of speaks for itself. You've got an unarmed fleeing suspect, guilty only of a misdemeanor, who's shot in the back 5 times. And then the officer on video manages to drop a gun next to his body.
It's murder.
It's murder. We got to call it what it is. I have seen in circumstances, tragic circumstances. I mean, I had one last year, heartbreaker. Multiple year officer, retired state officer, working at a senior level in a department, dealing with a young man who was busy with a baseball bat, chasing his wife around the house while she's protecting the children so that she can give him some more Xanax. Him and his buddies some more Xanax. And when he gets restrained and he's busy cussing and spitting at the officers and is told repeatedly not to spit at the officer, he spits in the wrong guy's face. Momentary lapse of judgment, he gets hit in the face a few times. The officer realizes what he does, he goes back to his car, he disengages. He didn't have to be told to disengage. Now, the officers there on the scene, they had a duty to tell him to disengage. He did it on his own. He gave truthful statement. Justice Department investigated. He went in front of a federal judge, and the judge sentenced him to court costs, nothing more. He had to do service, training, telling his story and sharing his mistake on a training basis, but his career was over. Now, that's just a minor use of force, a minor lapse in judgment, but at some point, these circumstances of these deadly force incidents, you've got to get a handle on them. The public perception in social media does not match the law. I would say that with presidential appointments being what defines the law long term, how the Constitution is interpreted, expect that social media's view of the law will become more like what the law is. Right now, I mean, everybody in here is pretty much senior officers. You know, we look at a Graham standard, we look at the seriousness of the offense, we look at the reasonableness of the force used. But what I'm seeing more and more is unintended consequences of even routine non-deadly force getting heightened attention, if you will. There is a need for your safety, for everybody's safety, to just be aware of the circumstances. And it's one of those, maybe when we're done and we have our question and answer, that we should probably talk about, because y'all can help us. I got to sit with folks sometime who, many times, have used deadly force. It's not an easy thing to go through. You know, even when it's necessary to protect your life, necessary to protect somebody else's life, which is the reason why you should use deadly force, is to go home as a last resort. Even then, it's a tough thing, and there's so many issues difficult for us to cover here in terms of crisis counseling, in terms of post-incident investigation, in terms of transparency, in terms of policy development, that you know, all I can say is I know it's got your full attention, but it's got ours in defending these kind of cases too. I can say this: when somebody is pulled over, you know, the first thing you do, the first use of force that you have is when you engage your blue lights. From there, if it escalates, whose responsibility is that? The person should cooperate and comply, and then it doesn't escalate. If the person doesn't cooperate and doesn't comply, constitutionally, if you've got a right to an arrest, you've got a right to use the level of force necessary to get the job done. It can't be an unreasonable level, but just in regular terminology, the choice is not always yours, and that's unfortunate, and that's not what society sees. And we've got some numbers and some things here that are worth your attention in terms of perception. It's not that you don't already know. Like I said, we've got a senior group here. You're used to a Graham standard. Everybody has been trained to and looked, I would assume, on the use of force pyramid. My preferred way to look at that is deadly force is the last resort, but you guys go home, and then we'll deal with it if we got to. Deadly force, it should be the last possible thing you do, but if you're not given that choice, you know, you set the threshold of force out there for somebody to comply, and they don't. They force an escalation of the force. Your choice is to disengage and let the conduct go, or your choice is to not defend an innocent citizen or not defend a fellow officer. Those aren't necessarily real choices, and the rest of the world doesn't understand that. But when we get down to use of force, public perception is tough. And we stuck some older numbers here. I really would probably be frightened to update this. You know, 2008, 74% of the people interacting with law enforcement in use of force situations thought it was excessive. Now,
that number's gone up.
oh, look at Twitter. The night of that Dallas shooting, I don't know why, I'm not glued to the computer, but I looked on Twitter and I followed the Dallas Police Department. I don't know why. I saw something from them ages ago and I clicked, and it was showing pictures of the police department marking off the intersections, and it showed the progress of the protest. And it literally, before the first shot was fired, there was a picture of police units marking off the intersections, pictures of peaceful protest. And it was saying that, you know, the police department is protecting these folks' right to peacefully protest. I've never seen anything like it. I don't think any of us have. But that's the reality of what the world is seeing. And if they don't see it on social media and they turn on their TV, one or more politician is going to be advocating the position of somebody who was injured in spite of resisting arrest, in spite of behaving in a threatening manner. It's unfortunate, but it's just the reality. But that's just the reality. That jury pool. And in federal cases where the issue is use of force, and if it is debatable, the standard most recently, I looked at a Fifth Circuit case I just cited in a brief, and the facts kind of go like this. You had an emergency call to a residence claiming an armed burglary. 3 officers respond. 1 is equipped with a canine. The officer with the canine is in the lead. A male subject is there. Turns out not to be the source of the call, but he makes a move that the officer with the canine considered threatening, as though he were going for a weapon. Unfortunately, the officer misjudged the situation. The officer released the canine, and simultaneously with releasing the canine in close quarters, shot the guy 5 times. Then with the canine on him, rolled over, shot him 2 more. Now, the Fifth Circuit, looking at that, applied qualified immunity standards, and it's mind-blowing. They did not overturn qualified immunity for releasing the canine or for the first 5 shots into the guy's torso as he was facing the officer, in spite of the fact that he was shooting somebody with a dog engaged at the same time. But they did send it back for the 2 shots in the back. Now, realize that's an extreme set of facts. The law's going to catch up to that. Social media is already second guessing us. I'm just, it goes beyond publicity to one of real life concern when people start taking aggressive action toward officers. Anyway, we can skip through to public records and investigation. But this is a more senior group. If there is a use of deadly force within your department, have a policy. Most departments do. Have a policy that governs your response. It needs to provide, or it is recommended that it provide, that you have an outside agency get involved immediately. The applicable state agencies used to getting that call, and they get there really fast. You need to have some protocols within the department of who the liaison needs to be. As I said, sometimes my preference is that not be the sheriff. I've got my reasons for that, and I'm happy to explain it from a policymaker standpoint. But all available evidence within the department that somebody may want with regard to the incident needs to be preserved. That means your use of force policy, that means your training records, that means history of prior incidents, if any, involving the officers involved. That means cooperating with the outside agency investigation. That means making sure that the individual officers involved have a cooling off period and the opportunity for counsel before they're put on the record. I cannot stress with you enough. If there's something like this, with all that adrenaline flowing through your head and all those things flowing through your head, it is strongly recommended that there be a cooling off period before anybody is put on paper, and that they have the opportunity for counsel. We give shoplifters the opportunity for counsel. Certified officers facing an investigation that may or may not be criminal, but will most surely be civil these days, they need a lawyer. They need a time to cool off. They need a time to explain themselves, not be coached, but a time to have the same legal rights and the same advice that a common shoplifter would have. Now, we've got some hypotheticals here, but we can skip through to arrest and detention.
An arrest, when a reasonable person would believe they are not free to go. You do not have to say that you're under arrest, right? You don't have to handcuff them. You don't have to, you don't have to use words if you use intimidation. There's a case where a large guy cornered somebody, and it was clear by his body language that that person was not free to go. That person was under arrest, right? In Mississippi, we love to work things out, so I've had more than a half dozen to a dozen officers tell me, I didn't arrest him. Just took him to the SO to work things out, all right? When you put him in that vehicle and he's not free to go, he's arrested. I literally had a deputy one time make an arrest, and it was really, this guy was taking well water and pouring it out in a creek on this other guy's property from the public roadway. He was pouring it into the creek, and it was killing a bunch of fish. And this guy got mad, and he called the cop, called the sheriff's department. The sheriff's department come out there, catch him doing it, arrested him, put him in a car, took him to the SO. Plaintiff's lawyer was deposing him and said, you arrested my client. No, I didn't. Well, you put him in the car? Well, yeah, I did. You took him to the sheriff's department? I did. Why? Well, we went to look in the books and see what we could charge him with. He wasn't under arrest? No. We just working it out. No. The minute that person is not free to go, they are under arrest. When can you arrest a citizen? Well, the best chance is with a valid warrant, right? Validly issued warrant, which means somebody didn't lie to get it, is the best circumstances to arrest somebody. But you can also arrest someone for a misdemeanor committed in your presence. You can arrest someone for, if you have probable cause to believe a felony has been committed or is being committed. So this leads us to one of our more fun topics of the day, and that is public profanity. Oftentimes it seems like we come down to public profanity versus disorderly conduct. Which of these should we charge under? If you didn't know it, the public profanity statute in Mississippi has been declared unconstitutional. As Danny says, it's like Confederate money. It's on paper, but it's worthless. You can't arrest somebody for public profanity in Mississippi. I mean, you can, but it's unconstitutional. Now, this is the point where when I'm teaching these seminars, somebody, typically a large southern man, jumps up and says, in this particular accent, "You telling me I can't arrest somebody if they call me a mother trucker?" And I say, yes. "Well, that's not right. You can't cuss me in public." "Yes, I can." "No, you can't." And I always say, me and you are going to get to be good friends. We're going to spend a lot of time together. I'm going to get to defend you. In Mississippi, the public profanity statute is still on the books. It says you shall not profanely swear or curse. Got to have 2 or more witnesses, right? Just like the Bible. 2 witnesses. Although it's still there, it's not constitutional. The First Amendment says that the Congress shall make no law abridging freedom of speech. It applies to the states through the 14th Amendment.
I've listened to you do this a couple times. Now, part of that statute about cussing in public isn't valid.
The public drunk part still is valid. That's true. You can't arrest somebody for public intoxication.
If I'm a law enforcement officer, if they're cussing me, they must be drunk.
Don't listen to Mr. Griffith, please.
Okay.
As early as the 1940s, the U.S. Supreme Court recognized instances where you could curb people's language without running afoul of the First Amendment. That's why you can't say fire in a crowded room, right? That's not freedom of speech. If I'm sitting in a movie theater with 300 of my finest friends and I scream fire in the dark, that doesn't run afoul of the First Amendment to arrest me for that. The problem is we still have these fighting word statutes on the books, these public profanity type statutes. Case law says that fighting words are those that incite a breach of peace. How does this apply to law enforcement officers? Well, early and often the United States Supreme Court, as opposed to the Mississippi legislature, the United States Supreme Court has said that cussing is just not a crime. This was a case where there was a public protest during the Vietnam War, and they were trying to get people off the streets, and one of the people that was protesting said, "We'll take the effing streets later." They arrested him. You can't arrest somebody for that. Danny always says it's a bad idea to arrest somebody for what they say.
For anything.
Yeah, it really is. In most circumstances, that's true. 1974, Lewis versus City of New Orleans. This officer actually got obscenities yelled at him, cuss words. Tried to say it was the fighting words exception. We can arrest this guy. The court said a properly trained officer may reasonably be expected to exercise a higher degree of restraint from the average citizen and thus be likely to respond belligerently, less likely to respond belligerently to fighting words. You know, this is especially problematic in the South, where we take things a little more seriously. I've got some Yankee family, and they talk to each other in a way. I mean, I've got a little niece that calls me by my first name and says yes and no to me instead of yes sir and no sir, and it just about kills me. But they're also very prone to use words that if you use that towards me, I'm likely to run around and hit you in the back of the head. Unfortunately, the Supreme Court is not full of a bunch of Southern people, so they don't see these words as being very. We might think it would incite a riot, and they wouldn't. So the long and the short of it is, you got a right, now that we've hired you as a law enforcement officer, to be cussed and to have your family talked about poorly, and there's nothing you can do about it. You with me? That's what the court has said. The First Amendment protects a significant amount of verbal criticism and challenge directed at public officers. More recent case, 2016 case, Brooks versus City of West Point. This is kind of funny because Mr. Brooks, it's a mister, he calls 911 because his sister was picking on him. Officers get to his house and he thinks not twice before he starts cussing our officers. Now, this fella is going to call 911 because his sister's harassing him, but he's going to cuss our officers. Unfortunate place that our country has come to. He did not verbally or physically threaten the officer. He did not make any threatening, combative, or other overt gestures towards the officer. He just cussed him. He later sued after the charges were dismissed. The court dismissed his wrongful arrest claim, saying that the officer had probable cause based on fighting words, that he cussed him. The Fifth Circuit reversed that. It's regrettable when police are summoned and respond only to be cursed. But viewing the facts at the time of the arrest in light most favorable to Mr. Brooks, no reasonable officer could have believed he could arrest him solely because of the words he used during his first encounter with Officer Birchfield, which constituted neither fighting words punishable under the First Amendment or disorderly conduct. So, you have got to have thick skin. I one time had a deputy pull a suspect through a window because he cussed him in front of his kid. It was right when the pseudoephedrine law had come out. He was in a pharmacy. The next day that pseudoephedrine law went into effect, the guy still had the precursors all out over the pharmacy, and he, as a kindness, told this pharmacist, hey, look, tomorrow's the deadline. You got to get all this put up. And he had his little girl with him, and that guy took to cussing him, and he did not know this officer like I did. I had defended him several times. He reached through that pharmacy window, and before that long-haired joker knew it, he was out on the ground. He had pulled him through the window. That's unfortunate. You got to have thick skin. You got to let them cuss you. It doesn't matter if they talk about your wife, your baby, or your mama.
If he spits on you, what do you do?
That's assault. But you know what you do, honestly?
Arrest him, take him to the grand jury is what you do.
Yeah. You know what you really ought to do is wipe it off and take a step back. And today, the way things are, that'd be the best thing to do. But it would be assault. What do you really need to make an arrest? You need a threat of physical harm. You need overt actions that amount to a threat of physical harm. Or you need him to disobey a lawful order. That's when I put up that slide that says public profanity versus disorderly conduct. Much better to go with disorderly conduct. If you can get, if you tell the guy, listen, you need to calm down and back up, and he doesn't obey that order, he has just disobeyed a lawful order. He's arrestable for disorderly conduct. I'm not telling you that I think that's great, but I got something I can hang my hat on. I can't hang my hat on the fact that he called you a son of a bitch. That won't work. You with me? You may not like it, but it is the law. Danny's going to talk about this case, but I included it just to kind of tell you how things have changed. This was a decision that came down last year Guy got pulled over on a traffic violation. Guy wrote him a ticket. When he had finished the ticket, he decided, you know what, I really ought to have a drug dog sniff this guy. He asked the guy if he could. He said no. He said, well, wait here anyway. Got the dog there in 8 minutes. He sniffed and left. Didn't hit, I don't believe. That 8 minutes that he had, it ended up being an arrest. Because he had finished the ticket writing process and was completed, he had no valid reason to keep him there. And the United States Supreme Court said that amounted to an arrest. That's different than what we've had in the past. The court system has changed a good bit, not just on the local level, but on the federal level at the highest echelon. It's changed. It's not as protective of us as it used to be. This is something that is very, very new that I wanted to warn you about. I'm certain that you all get the opportunity to serve mental writs. I'm certain that you love it. It is a terrible use of our time and resources, to be honest. Mississippi's jails aren't meant for people that have mental problems. We ought not have to fool with this, but we do. There's a state statute that requires it. In my experience with my agencies in the south part of the state, we routinely help one another. If there is a writ to pick somebody up, a mental writ, in one county and a sheriff finds him in another county, it's nothing for us to pick him up and execute on that writ, help our buddy out, because frankly, none of us have time for everything we're supposed to be doing, right? We had this occur recently. Jeff Davis County had a writ out for former Mississippi State offensive lineman, 6'6", 400 pounds. He was a load of man. He was going about 110 through an intersection, ran a red light and ran over one of our deputies on patrol, nearly killed him. We got out there to investigate it, and he was acting pretty crazy, had a 9mm stuffed down his pants. We started dealing with him. His mama got out there on the scene pretty quickly and said, listen, we filed papers on him yesterday for a writ. My sheriff calls Jeff Davis County and says, hey, is there a valid writ out for this guy? And he said, yeah. He said, do you want us to pick him up and take him to the hospital for treatment and let you get him there? Please. Turned out they weren't real excited about getting this joker because he was 6'6", 400 pounds. He was pretty tough. We executed on the writ. He sued us because it took a good bit. It took 5 men and 3 tasers to put him down. He just wouldn't be subdued. We filed a motion to get out of the case because we had a valid reason to arrest him. He had failed to obey, and we had a writ to pick him up. Probable cause. I mean, it's not probable cause. It's based on a warrant. The judge denied our motion and said that we had no right to pick him up on that mental writ because it was not issued in our county. My sheriff's county was not the way it was issued. Now, keep in mind, this has been the way that, I don't know about up north, but in the south, this is the way we've done it in the south part of the state for, 40 years. Yes, sir.
Is Jeff Davis and Lamar in the same chancery?
Interesting that you should ask that. You would think that would make it okay, but it wouldn't. It wouldn't.
So
they are, by the way. But what the judge said he should have done was they should have had it issued out of the Lamar County Chancery. Now keep this in mind. Think about this. One of the most difficult things families do is go file petitions to have their relatives committed, right? They file it. He goes and is found in another county, and my sheriff's going to call him and say, hey, you're going to have to file that in Lamar County if you want me to pick him up. Sheriff can't file the petition. So all you got to do is stay one county ahead, right? A lot of these guys, that's not a big deal at all. You issue a writ in Jeff Davis, they go stay over in a trailer in Lamar. You come issue it in Lamar, they're going to go stay over in a trailer in Forest. So you just hop along and stay away from them. We think it's a very, very bad ruling, and for that reason we've appealed it. We've gotten an interlocutory appeal, which is an immediate appeal that's on appeal right now at the Fifth Circuit. Our brief is due 2 weeks from Monday. It's going to be very interesting. Argued 2 bases for the, well, really 3. We said 1, we had probable cause to arrest him even if we didn't have a warrant. We had 2, we had a warrant. And 3, even if we didn't have a warrant, it was not clearly existing law that you couldn't do this. See, to have liability for an individual officer, that qualified immunity kicks in. not only do they have to show a constitutional violation, they also have to show it was clear to every reasonable officer, you shouldn't do this. I had 8 people on scene from 3 different agencies, all of whom agreed this was okay. Yet, the judge found that no reasonable officer would believe it's okay. 8 people, 3 different agencies. So we've appealed it. But what I had to tell everybody at the sheriff's conference this past June was, for the time being, I would not have you execute on any writ that was not issued out of your chancery court.
I remember my cautionary word on warrants. You will see more and more in litigation simply because you were acting pursuant to a warrant. They just attack the validity of the warrant. So make sure you've got a good warrant. Make sure it was obtained properly. Make sure if something comes up that you've got everything you need, because we're going to have to look and go through what we've got to go through. If they're going to lie and accuse us of lying on warrants, we're going to have to go through in these cases and be able to prove that the warrant was validly obtained. That means probably you. That probably means your underlying facts and circumstances. That means probably getting the justice court judge who issued the warrant to testify. And if you can, well, we all work together, so if y'all can think of other things that we need to do to be able to prove that, they'll give up on this argument after a while. But for now, instead of simply not suing you for acting pursuant to a warrant, they're going, in many cases, you're going to get accused of lying to the judge. And I can tell you how it's going to go, but it is what it is. When you don't have a warrant and it is a search, it's a burden shifter. We need to be able to prove that you had a reasonable basis to conduct the search. Now, it depends on what kind of search. We all know a Terry type search. A reasonable articulated suspicion of criminal activity will get you some minimal investigative power. I mean, you know, you can't reach your hand into a pocket, but you feel a knife in a pocket, you can reach your hand into a pocket. One thing leads to another. The best example of that I had was I had one on the side of the road in Tunica County with 3 very intoxicated redneck gentlemen. Had some issues at the gambling tables, and the African-American security officers at the casino attempted to escort them out, and they started making racial slurs. That aggravated the casino employees to no end. They called the law, and when the law arrived, they'd been responding to armed robberies from the casinos, and so they showed up blowing and going, guns drawn, full felony stop. We essentially had 3 handcuffed drunk guys on the side of the road in Tunica until we finished the investigation. Literally took one of them back to the casino and was able to determine that, now wait a minute, this might be drunken conduct, it's offensive conduct, but nobody's committing any armed robberies, and they drove them home. Well, then they hired a lawyer and sued us for unreasonable restraint, now in false arrest. What we did is, in the litigation, we emphasized we had a reasonable suspicion that something bad had happened. We get a felony call. So basically used a Terry type stop, a reasonable suspicion stop, and was able to show that the detention on the scene was reasonable, that the investigation naturally followed, the officers were professional, and carried forward from there. So realize with searches, when we don't have a warrant, we're either looking for probable cause or some exception, but we don't always have to start with probable cause. We can take little baby steps and show reasonable suspicion. Without a warrant, it's going to have to fall within an exception. Experiences that I've had. Let me give you a circumstance. There is a well-known marijuana dealer, and he won't make a sale to you. He will drive across the state line into Memphis and make a sale. But he's playing with jurisdiction. It's hard to get enough specifics to get a warrant on him. So why not stop his wife down the road and come to her with a piece of paper and say, hey, we've got a Crime Stopper tip. There's a felon hiding in your house. Would you give us consent to go look and make sure everything's okay, ma'am? Why, certainly. Officers go in, observe evidence. Based upon the evidence, they have more than enough detail to get the warrant that they need to go search the residence, yielding 5 pounds of marijuana, which, wow, that's a lot. That's a big pile. Is the consent to search valid? No. Consent has to be free and voluntary. You cannot trick them into it. It has to be. That's all TV and movies. It doesn't work that way. Now, you can trick them, but you can't trick them and use consent as a basis. They're not consenting. Search incident to arrest, is always a viable basis. An inventory search is always a viable basis. Vehicle searches want to lead into where we historically have been, and do a little bit of discussion of the Rodriguez case. Used to be, you pull over a vehicle, you could search within the reach, lunge, or grasp. You're looking for being able to make sure that somebody doesn't have a weapon or contraband in the passenger compartment of the vehicle. Supreme Court cases came along, and y'all have the PowerPoint, and evolved. They recognized that automobiles, some people basically live out of their car, including me, because I'm on the road so much, but an automobile just does not have the same characteristics as a home. And the Supreme Court took that into account and loosened up a little bit how far you could go. At every step, you need to be able to articulate what you're doing. And like I said, I'd always rather have consent or a warrant. Then we come along with the Supreme Court in, when I can get there, to Rodriguez. They had a car stopped on the road, finished writing the ticket. The fellow wouldn't consent, but they kept him there 8-10 minutes to wait for a canine to get there. When the canine got there, obviously there wouldn't have been a case. The canine obviously found dope in the car. Once all of the necessary processing is over with, there was no reason to hold him. Therefore, the search was unreasonable. Now, within 3 or 4 months of this, I immediately had a suit on it. I had two couples, they're heading to a boxing match. And they are pulled over for expired tag, some kind of miscellaneous traffic violation, and they won't produce insurance and identity information to the officer. They have a profound legal expert in the back seat who demands to talk to the officer's supervisor. Well, ma'am, you still got to give me that information. The officer patiently and calmly tries to explain. But they would have nothing of it until the officer's supervisor showed up. They wouldn't produce the information. So fine, they kept them there on the side of the road for 45 minutes until the supervisor got there, then complied, then were released with their citation and drove off down the road. Constitutional violation? No. They're the ones who, it was their fault. Everything was documented. The officers' reports were clear and clean as for the reason for the detention. The radio traffic identified exactly what was going on. Every time a new Supreme Court case comes out with a new twist or turn, somebody is going to explore whether they can turn that into civil liability. Now, if in that circumstance we had a Rodriguez-like case where the delay was simply to get a dog on the scene, it wouldn't be reasonable. We didn't arrest them for anything anyway. We wrote them citations. It was just a test case. But realize on these 1983 claims, if you prove a violation, you get to recover attorney's fees. So, and the going rate on the attorney fees is way more than Mr. Allen and I made. So it's a free shot at getting attorney fees. Anyway, that's why we emphasize the searches. A cautionary point on administrative searches and roadblocks, and this is more for your safety than before a liability issue. One of the saddest cases I ever had to deal with was with a situation where there was a security checkpoint, roadblock for all practical purposes. Departmental policy, they had it all laid out. This is how we do it. You know, you bracket the stop, you make it a location clearly visible for officer safety. Officers are to wear reflective clothing and to have flashlights if at night. Somebody turns around at the bottom of the hill, one of the officers leaves, it leaves an officer only on this side of the road. Now, if I'm a motorist and I'm in Mississippi and I'm driving down the road and I come upon a law enforcement vehicle that is on the right side of the road with its blue lights on, what am I commanded to do? Move over. Guess where the officer was standing without his orange on? Sad, sad, sad. Y'all be safe.
The finish line is in sight. We're going to talk about 2 more topics after this, and this is one slide. But it's very significant. Heck versus Humphrey is a United States Supreme Court case that essentially says you cannot collaterally attack a criminal conviction by way of a civil action under 1983. What that means is you can't attack when you get criminally convicted by filing a 1983 suit. So if you get convicted of DUI, you can't later bring a civil suit for false arrest. Because if you were falsely arrested and you succeed, that undermines your entire conviction. You see what I mean? So the key to this is you got to go get your charges and follow them through and make sure you get convictions. Don't let prosecutors remand them to the file. I mean, sometimes they're going to do that even if you don't want them to. But that's one of the worst things that can happen is if you can get a conviction, it's going to knock out 85–90% of a civil lawsuit. I've got good relationships with the DAs and assistant DAs in the south part of the state for my agencies, and they'll often call me and say, hey, we're going to dispose of this claim by doing this. Is that going to help you or hurt you? And if it's going to hurt us, I say, hey, don't do that. Don't let them plead to the lesser offense there. We need them on this offense so it gets my guys immunity. And they'll push for it. So what that means is if you have enough to charge somebody, follow through on those charges and get them prosecuted. You're doing yourself a disservice when you say, oh, yeah, that's fine. Just let them remand them to the file. It's not a good idea.
No, when you're at municipal court or justice court and you see the plaintiff's attorney who regularly sues the police showing up with your suspect to defend him on a bunch of charges, don't let a bunch of plea bargaining go on back there that gets you sued.
That's right. Any questions about that?
Initial appearances. There's a lot of misinformation about initial appearances out there. The first misinformation about initial appearances is how soon you've got to give somebody an initial appearance. If they're arrested without a warrant, as soon as you can. If they are arrested without a warrant, that is a Fourth Amendment right, and the U.S. Supreme Court says as soon as you can, to paraphrase. That means promptly after arrest, generally within 48 hours. It can be unreasonably long if it is 48 hours. Now, an arrest pursuant to a warrant is different, but you still should follow the same time frame because of what an initial appearance includes. You see, with an initial appearance, we're doing a couple of things. We're getting something off our plate. We're having a judge make an independent finding of probable cause. And it's made right then and there when the person has a chance to speak up. So They might want to come in and accuse us of lying and accuse us of this and that and the other, but if you do that initial appearance, that judge, when he holds them on that initial appearance, he's made a probable cause determination, and it breaks the causal chain of a false arrest. So you are protecting yourself. That initial appearance gives a chance for the judge to determine the indigent status of the offender and provide them with counsel if necessary. That's the biggest excuse that I hear is we couldn't get the judge. Our justice court judges only work on Tuesdays and Thursdays. That doesn't matter. It doesn't matter if it's Christmas. It doesn't matter if it's Sunday. It doesn't matter if it's Easter. It doesn't matter if the judge is fishing. The judge can do an initial appearance by phone in an emergency. And when is an emergency? It's when you can't do it right now, get him to do it by phone. I wish I could tell you different. I wish I could tell you take your time, but it's too easy for you to get sued. I want to pass the potential liability on to somewhere else. If we're looking at a scenario of a prosecutor and a public defender, a law enforcement officer, and a judge, the judge is probably going to be immune if he's got subject matter jurisdiction, which all that means is I hear those kind of cases. So unless a Chancery Court judge is holding your initial appearance, he's probably going to be immune unless it's a felony. We're going to get to that. The prosecutor, if he is doing prosecutorial things, not kicking down doors, playing law officer, then he's going to be immune. The public defender, that's a whole different avenue, but he's not going to be chargeable to the county under most instances. That leaves the law enforcement officer. Guess who they're going to sue? Now, you got qualified immunity. We have immunity provisions under state law as well. But that's where it's going to come from. What excuses can we make for the delay? We've already said the judge went fishing, doesn't get it. Gathering additional evidence to justify the arrest. What Wills calls an investigative detention. There is no such thing. I hear about it on TV. We're holding a suspect of interest pending charges. There is no such thing. Get a warrant. Get an initial appearance. You certainly can't hold somebody because you're mad at them, because they spit on you, because they cussed you for any personal reason. You can't hold them just because you can. I'm going to lock you up in the cell. I got 48 hours to get you to a judge. No, you've got to get them to a judge as quickly as possible. And this is stuff I don't like having to tell y'all, because I know it is not fun to have to hear, because in addition to everything you've got to do and worry about somebody telling lies about you on Twitter when you do your job, you've got all this administrative task that shouldn't be your job, but you're the one that's going to get sued. Now, there is a local rule on initial appearances, and there are statutes, and there's the United States Constitution, most of which are not sitting around in the typical sheriff's office. By state statute, though, look what it says. Every person making an arrest shall take the offender before the judge without unnecessary delay. That means right now, and that means they're putting that duty on you, on the arresting officer. Now, there are exceptions to that. I'm going to get to that. But here's a rule here. Does anybody have the Mississippi Rules of Court sitting in their sheriff's department? Nope. You know why? Because they're court rules. Their court rules are adopted by the Mississippi Supreme Court for courts, for judges. Judges, prosecutors, defense attorneys, they use them. Yet, guess what? This essential duty that's getting prescribed by the Mississippi Supreme Court, as spelled out in the United States Constitution, will get you sued. So, I mean, I know I keep saying it over and over again, but I'm hoping the point makes it. They're just, that's it. Now, why? Why are they gonna sue us? Like I said, the first reason is that probable cause determination. If we've got that probable cause determination, and they come in, they try to sue us, and they say, you arrested me without probable cause. Now, in a perfect situation, I'm gonna say, oh, but the grand jury already indicted you. Or, oh, a warrant was issued for your arrest by a judge already, a good valid warrant. But if I don't have that, I'm still gonna get a probable cause determination when I take them for an initial appearance. It just makes it easier. Beyond that, you're gonna have to deal with, if I can get to a worse situation. Here we go. Let's take hypothetically the situation of a circuit court handing down an indictment. They issue a capias, which is just a warrant, but it is a warrant issued on a felony, and it's a warrant that is returnable to circuit court in term. It is a warrant that can be exclusively handled by circuit court in Mississippi. That means that you can't run them next door to the justice court. That means if your sheriff's department has a justice court inside, like some of them do, or if your sheriff's department right next door has the justice court, or if the justice court judge, to accommodate you on initial appearances, comes by the jail or does telephonic hearings so that he can do all this, it doesn't matter. He can't do it. There has to be a district attorney and a circuit judge and a court reporter and everything that they do to do an initial appearance in circuit court. Now, who sets those? The court administrator, who works for the circuit clerk, the DA, who has a secretary. Who gets sued? Does anybody want to guess? Yes, that's right. Now, the best thing I can say on the subject, the best recommendation that I can make is, even if the judge is not, if somebody comes in on a capias, well, what we're going to do if they come in and it's something that you can get a justice court judge to do, get them the justice court judge. And if the justice court judge doesn't want to do his job, put it on the agenda and go in front of the board of supervisors. Get the board attorney involved, get the board involved. Justice court's got, judge has to do his job or he's going to get you sued. I mean, it's that simple. If it's a circuit court judge, you're going to have to do something proactive. You're going to have to hound the circuit judge's office to do their job. And that's kind of tough to do. We won't get along with the circuit court judges. We get along with the circuit court judges if we have sense. Guess who has exclusive venue of our Tort Claims Act cases? The circuit judge in our county. The last person that you want to tick off. But you're going to get sued for denial of counsel, denial of reasonable bond, and holding somebody without sufficient probable cause if the circuit court judge and the district attorney don't do their jobs. Now, we've got this issue pending, and we may very well win, remembering that qualified immunity protects you unless you are blatantly wrong, unless every reasonable officer would believe your conduct to be unlawful. But being proactive, get them in front of a judge.
We're going to finish with a fun topic here. Recording police activity. More and more, this is coming around. Some of you may have seen this. It's not as much fun without the audio, but it's pretty darn obvious what's happening. Who's seen this? Anybody recognize it? U.S. Marshals. Yeah. See right here, she got a cell phone. She is not mouthing off to them. She's just saying, hey, I'm just recording what's going on.
She's not in his space.
No. Now watch. Here comes big boy. Tough guy. Whoop, let me have that phone. I'm going to spike it and then kick it. That fella.
He's now retired?
Yeah, I believe is now retired. If not, I can assure you he no longer works for the federal government. Because what he did was patently unconstitutional, and although she suffered only, what, a couple $100 in damages, new phone, the wonderful thing about Section 1983 is Section 1988, attorney's fees. So her attorney got attorney's fees after he brought that case, which would range anywhere from $50,000 to $100,000. It's probably on the lower end because it wouldn't have taken much to whip that tail. You can't do that if you didn't know it. Can't do it. According to the Pew Internet and American Life Project, which is a project that studies American phone and internet usage, 87% of Americans had a cell phone. That's in 2012, their latest data. You know that data is higher now. That number's higher. You can't find people without a cell phone now. I can just sit down now, can't I? Can they record it? Yes, they can. No more. Let me give you a little background on it, and we'll kind of talk about it. The first big case on this was Glick versus Cuniff, and I've had a lot of fun in these seminars talking about our plaintiff, Simon Glick. You just say his name and you can picture him in your mind, can't you? Little pencil neck sucker. He's just walking along Boston Common. Here's a commotion. Here's those words he so yearned to hear. Stop or you'll hurt him. Rather than go over to see if the officers need help, he goes over to see if he can videotape someone doing something wrong. My, how the world has changed. He ends up videoing part of an incident. When it was over, one of the officers walked over and said, "Hey, you've had enough pictures. Move along." He doesn't like it, gets smart. The officer, not unintelligent himself, says, "Hey, has that got audio on it?" And the guy said, Mr. Glick said, "Well, yeah, it does, as a matter of fact." Bam, he arrested him. Massachusetts had a wiretap statute. You could videotape, but if you video and audio, you had to have consent from the other party. He had no consent, so he arrested him. He was charged with 3 different violations: the wiretap, disturbing the peace, and aiding in an escape of a prisoner. The district attorney would not even fool with these latter 2 charges. He tried to bring them up. They were dismissed pretty quickly. At that point, the prosecution said, you know, we're not sure, but we're going to go forward on this wiretap. Got dismissed. Mr. Simon Glick does what all great Americans do. He filed a civil lawsuit. The real narrow question here was, do citizens have a First Amendment right to record police activities on police business? The officers argued they did not, that it interfered with their right to do their job. The First Circuit Court of Appeals vehemently disagreed and held that there was a constitutional First Amendment right to record police activities. There's some good quotes here. I like here the second quote. Freedom of expression has particular significance with respect to government because it's here that the state has a special incentive to repress opposition and often wields a more effective power of suppression. We don't want the government to be able to control the flow of all information. I know everybody in this room right now is government, including us that work for government, but we don't want the government to completely control the flow of information. It's particularly true when we're talking about law enforcement officials because that would allow you to misuse or deprive people of their liberties. If we could control the flow of information, we couldn't stop the bad cops. The court in the First Circuit basically said, you got a right to do this. The Department of Justice became involved in this case as well as a case in Baltimore. They ended up producing a handout that's pretty handy on what you should and shouldn't do when it comes to folks recording your activities. I mean, has anybody yet had this happen where somebody pulled out a cell phone and recorded them?
Every day.
That's it. I mean, this is the new normal. This is the new normal. The Department of Justice points out that people have a right to record in every common public space spaces that we've always considered to be public, parks, roads, streets, sidewalks. There's a right to record police activity. They also have that right on private property. If someone's recording from their home, they got a right to do it. There's a great case out there with video where a guy's standing in his yard recording a stop. One of the officers finishes the stop, walks over and snatches the phone away. They got to pay some money. You can't do it. That's a good summary right there. Individuals have a right to record police activity if they have a right to be present. You can't threaten, intimidate, discourage, and or cuss folks recording your activities. I laughingly told the groups these last 2 days that I've got a great video. I had an officer in the eastern part of the state who tased a guy, and the guy deserved to be tased. He wouldn't be subdued. He ran. We had to do it. But it was all recorded on videotape, and the tape was great for us, except for the very end where my deputy walks over, stands in front of the camera and says, "And you tell the son of a that I'm the son of the bitch that tased him." Didn't look good to the jury. Seize a recording device without a warrant. You hear me? Officers cannot seize a recording device without a warrant. Criticizing police conduct is not sufficient criminal activity to allow there to be a seizure. Criticizing police is not criminal. That being said, there are limitations on what they can do. The most prevalent of which is they can't jeopardize the safety of officers, the suspect, or citizens. So if I grab my camera and Deputy Griffith is trying to make an arrest, and I'm over the top of him, you have every right in the world to tell that person to back up. Back up, give me a 15-foot buffer here. You're impeding our ability to stop this suspect. And if they don't obey that lawful command, you can arrest them for disorderly conduct, not recording police activity. Small distinction, but it makes all the difference in the world. You with me?
We're still probably going to end up having a federal lawsuit over it because they're going to accuse you of arresting.
But they'll have videotape of you saying, "Back up, sir, give me 15 feet. And I'd say it more than once. You're entitled to a buffer there to make an arrest. You're entitled to not feel like somebody's going to stab you in the back right there. They can't violate the law or incite a riot. If they start hollering, "Let's jump him, let's jump him," that's a problem. You're not arresting them, though, for freedom of speech. You're arresting them for disorderly conduct, inciting a riot. This one is, we've already kind of gone over. One of the real litigated questions on this right now is, what about gathering that cell phone for evidence? This can kind of be tricky. What if that video depicts criminal conduct and you need it? Can you gather it up and seize it? Well, the answer to that question really depends on who has the video. Is it a third party or is it the suspect? If it's a third party, the long and short of it is you need a warrant. If you cannot convince that person, if they're such a terrible citizen that they're unwilling to provide evidence of a criminal act, then you're going to have to get a warrant. And you can detain them for a reasonable time to obtain that warrant, but folks, it's got to be quick. You've got to talk to them, and while you're talking to them about voluntary consent, I would be having another deputy calling a judge to try and get a warrant. Just real quick, get a justice court judge on the phone, give them the underlying facts and circumstances, and have somebody at the jail run by and grab it and bring it up there. You want to do it as quickly as possible so that it doesn't become an arrest. The case law says it has to be temporary, only to preserve evidence until police can obtain a warrant, no longer than necessary. You cannot search the phone while you're waiting for the warrant. You can't look at the contents, okay? You can look at the phone, but not the contents. This is been specifically distinguished by the courts as not being like when somebody's trying to flush the drugs down the toilet, right? That's not the type of exigent circumstances you're facing. And there's a big First Amendment issue here. On the drugs, it's a seizure issue. On the phone, it's not only a seizure issue. You got the First Amendment involved because there is digital evidence on a phone that is highly personal. Courts recognize that. If there is a suspect that has the phone, you may seize that phone incident to arrest. The important thing to remember is that doesn't give you a right to then look at the contents. You still would need a warrant to look at the contents of that phone. The Fifth Circuit had this case, Rodriguez. They held that with a search incident to arrest, that you could, it was allowable to look at the phone to see what was there. It was analogous to a search of a container found on an arrestee's person. The United States Supreme Court said no, and they're the ones that count the most. They said that you essentially can look at the phone, you can look at the outside of it, see what it looks like, gather any evidence you can from the look of it, but to actually look inside it at the text, at the emails, at the photographs, you got to have a warrant. Shouldn't be a big deal. You've made the arrest, the phone's not going anywhere, you go get your warrant. It's much more difficult when you got a third party there who could do something to that evidence and they refuse to consent to allow you to have it. What Mr. Griffith and I have recommended is at that moment, what you're going to have to do is say, all right, you won't give me this phone, so I'm going to have to temporarily detain you while I get a warrant. Put the phone on the hood of the car. I'm not going to touch it and you're not going to touch it. That way they can't erase it. If they refuse to do that, you need to ask them again and say, listen, if you refuse my lawful command, I'm going to have to arrest you for disorderly conduct. Make them put it down, leave it on the hood so it can't be deleted, you can't fool with it, or somewhere, maybe not if the hood's hot, but get that warrant there and make it happen. We're finished, so y'all can hit us with what you want to hit us with. Let's go off. We're done with the recording.